Welcome everyone to the TiE Business Clinic Legal Series. Today we have our guest speakers, Ms. Juieen Nag, Mr. Dipankar, and Ms. Roopa Doraswamy. Just a little bit about them. Juieen has been a lawyer for more than 17 years. She now runs Riverdas, a legal tech company. Juieen is a trained mediator and affiliates with CAMP. In her previous avatar, she was the head of legal of RBS and SocGen in India. Hi Juieen, welcome. Welcome.
Thank you, Surya.
Is a lawyer and a legal technology entrepreneur. He is the founder, director of Riverdas Technology Solutions Private Limited, a legal tech company providing contract intelligence solutions. Dipankar is also a founding partner of Veris Advocates. Dipankar has a unique record of conceptualizing, designing, and selling legal tech SaaS, advising on many well-reported transactions, as well as representing clients on many complex disputes. Best described as the trusted counsel for business owners, passionate about law, regulatory trends, and technology. Welcome, Mr. Dipankar. Ms. Roopa is the co-founder of Flywork.io, a technology-enabled managed service platform that aggregates gig economy professionals in the legal and compliance field. She is a seasoned attorney with over 25 years of experience as a lawyer, founder, mentor, and law practice incubator. A graduate of NLS-IU, Bangalore, and Northeastern University School of Law, Boston. Ms. Roopa's career in the law prior to co-founding Flywork.io includes clerking with the judges of a court system in the United States, working at one of Boston's largest law firms, being the head of legal at Infosys Technologies Limited, and founding a law firm that went on to become a large law firm in India. Welcome, Ms. Roopa.
Thank you, sir.
I'll now hand it over to Juieen to begin the presentation.
Thank you, Surya. And I must say, after such a glorious introduction, like I was telling Roopa, I'm quite nervous, about this session, but I'll try and keep my nervousness as calm as possible. I would first like to thank CAMP for this opportunity to be able to present on contracts, legal services, and the gig economy to members of TiE Bangalore, and certainly to TiE Bangalore for providing this fantastic, legal clinic as a platform for us and for the startup owners to understand, the various legal nuances. So thank you, TiE Bangalore. Thank you, CAMP. And with that, we start our session today on contracts, legal services, and the gig economy. Going back to, kind of basics, if we look at what are contracts, contracts are nothing but a bundle of rights and obligations. And oftentimes they are expression of the organization's aspirations and goals. So it may not be completely wrong to say that organizations are an ecosystem of contracts. In fact, the World Commerce and Contracting, they conducted a survey, and they said 90% of the revenues of companies are recorded in contracts. So contracts are a very important building block of any organization, and there is no reason, why startups should be different. Even in startups, the contracts are a very important, building block. However, when we look at startups, we have to look at it from the lens of the time and cost efficiencies with which we can help startups contract better. So with that in mind, we will go into the session today, and I have as my co-panelist Roopa. She's a seasoned lawyer, and like Surya said, she runs Flywork.io. I have Dipankar as well, who's a partner of many crimes with me, and we founded Riverdas, a legal tech company, in 2017. My first question is to Roopa. Roopa, you have nurtured many startups. If you could throw some light on how important is is contract and contracting for startups?
Yeah. Thank you, Juieen. So to give you an answer for this, I need to kind of take you a little backward, because for me, I've seen startup waves almost for the last 25 years, starting with startup ecosystem developing in the US and then in India. Of course, businesses existed always in India. That's nothing new. Companies existed even before we coined the word startups. And you had business families, you had agreements in place, you had verbal agreements in place. The word of mouth was taken very seriously. Human relationships were what drove the businesses. So over the last 30 years, we've seen a huge change, okay, between what used to be businesses and who could get into businesses and what was involved to what it is today. Okay, and this is in the US and in India and other parts of the world. So, earlier when I was nurturing startups, and I've been in the startup ecosystem for a very long time because that just excited me. When I started my career in the US, they were just about starting term sheets, California, those draconian clauses, those huge agreements, they were all being put in place in the US. India, we didn't have all that then. And over the years, when we moved in here, back to India, we brought all those, I want to say good systems because of the way it professionalized a lot of things. So folks earlier who were business people and it was human content and also access to capital was limited to folks, everything got democratized, right? So now you have organizations like TiE literally create the ecosystem around what we see today. So if today access to capital, not right now, but access to capital over the last few years has been pretty democratized, it is because of what everybody has, these ecosystem partners have played over the years. And some people who've come back from being ecosystem players in the different parts of the world have really, inspired and instigated what is happening here. So that being said, what used to be earlier, and this is from personal experience, 15 years ago, when I was advising startups, I would say, okay, look at your company secretary, look at your, have your accountant ready, have your, yes, and then come back to me when you're ready. That's what I would say. But that's not the case today, okay? Everything is professionalized. The person whom you might have entered into a contract in the past may not be the same person when there is an issue, when the contract gets executed. And this is true even with startups. Yes, the founder starts the initial relationships, puts the system in place. But if we don't do it right in the beginning, right, then things can go haywire. This is more so when we start using the word startups. And I'm thinking when we're using the word startup, it doesn't mean a family business. It doesn't mean a lifestyle business. We're talking about, and the whole point of talking in TiE, especially TiE Bangalore, we are talking about scale. We're talking about probably getting invested, probably bootstrapping, which is good, but at some point also scale, right? We're talking about the world. We're not talking about interacting with different parts of the world, if that is what it is. And we're obviously talking about the startup ecosystem, Startup India Action Plan that is helping all of this also. So that being said, Juieen, the most important, from my own advice to startups today is take this very seriously. Take the processes that you put in place on day one. And I don't know if it's, if I'm being a little too generous if I use the word sustainable starting up. And I've been using that word for some time. I'm not talking about environmental sustainability, but I'm talking about just sustainability where you are building the startup in a sustainable way that can take you through life of the startup. So you don't want to be, spending your time on other aspects when you could have put certain things in place right in the beginning, put your roles and responsibilities and your rights and obligations in place right in the beginning, and done things right in the beginning. This will not only help people take you seriously when they make investment into you. You take yourself seriously. There is governance right in the beginning. Okay, so hopefully that will set the stage for us and how important contracting is at the startup stage. Whether you're not funded, whether you're funded, at whatever stage, Series A, Series B. It starts even with the founders. So I'll let you take the next step and then I'll come back as we want. Right? Yes, Juieen. Maybe Dipankar, do you have anything else to add?
Well, I think I fully endorse, Roopa, what you've said. I, I have had the opportunity of course, looking at early stage startups when they've sought legal advice. And then I have personally gone through the journey of setting a startup. And I think what is quite clear to me that there are a couple of things that are happening today. A startup's progress is today very rapid. A startup, as they are setting up shop, and from the time they have proved their concept, they have a prototype, and then they have their first customer, then they have their first investor in the company, and by the time they're in Series A, this can happen very rapidly. And all of them may not happen at the same time, but a startup's journey in India today has become quite rapid. So I think within a short span of time, both on the asset side, the startup is accumulating intellectual asset. They're hiring employees, onboarding contractors, and they're creating commitments. So look at this particular situation where a startup is very rapidly, and who are these startups? These startups are essentially founded by maybe young people, and maybe not so young people, but not always by in case of Flywork and Riverdas, by lawyers, but people who have been in other walks of business, maybe in technology schools, and they're coming together to set up the startup. Now, very soon they're entering into economic bargains which have significant liability implications of making payment, upholding the bargains, and they're also expecting the other side to uphold their bargain too. And it means that if they're hiring a consultant to give them certain services, they're expecting those services to be given on a particular time. If they're paying somebody money to develop a piece of code, they want the intellectual property of the code to be vested in the company. And similarly, I think in respect of the investors, there is a series of such bargains that the investors are expecting out of the startup, and the startups are expecting out of the investors. Now, I think the only thing that I add to what Roopa has said is that the speed has become 5x. And as I see, and I think it could be a function of the fact that the capital has been flowing very, very easily. But I don't think even if capital gets tightened, we will lose much of the steam and speed that we are seeing today. So what I feel is going to is happening in this whole thing is that startups need to start thinking about contracts very, very early on. Because if they are not thinking about these contracts, then it can soon start. They can soon start accumulating commitments which are difficult to keep track of, and they would possibly be missing on benefits that they have actually negotiated or bargained from counterparties of their contract. So my sense is that time is right on day zero to start thinking about contracts, because even by the time somebody has got the product and everything else, there has been many commercial milestones where contracts were important. So that's all I think. And as a starting comment, I think this is the time to start thinking about the contract.
Thank you, Dipankar and Roopa. I think, if I were to summarize what Roopa and Dipankar just said, I think Dipankar is clear that the speed is of essence, and therefore getting contracts right is a day zero requirement for startups. And Roopa's word of caution is pay attention to your contracts to be sustainable. I think these are aligned thoughts, and it just highlights the importance of contracts being an embodiment of your right and obligation to be done right from day zero. A natural question that comes to that after that is that, what could startups, given that, both of you have a fair amount of exposure to startups, and you have seen, you may have helped startups drafting their contracts, you have drafted contracts, you have reviewed contracts from other startups, what could startups do more or could do less in managing their contracts? Maybe Dipankar, you can start, and then we go on to Roopa.
Well, I think again, at the very beginning of this journey, the startups got to realize that the contracts actually represent And I think everyone realizes that, but when I say they got to realize, it means that the written words that are contained in the contract are supposed to reflect the state of truth of their commercial bargain. It means what they have commercially agreed with someone, that needs to be accurately reflected in a contract. And once they are accurately reflected in a contract, then there has to be a way of somebody to be able to refer to that reflection of the state of truth from time to time, because people may sometimes have hazy memory of what they have actually agreed to receive or to give, and to also when the time comes to be able to find that, because sometimes people may have to remind more strongly than usual times. What I'm trying to say, in other words, that before this before we get into the processes, I think what's important for any startup to realize their nature of the business, and from the nature of the business to understand, how the contracts, what are the minimum essential contracts that they need to actually have in place, and what are the main protection that they should be seeking in each one of these contracts. And this question is not a generic question. There is no one size fit all answer. There are many elements which every business would like to secure in each one of their contracts, and this could be common. And then there are some that could be very unique depending on the nature of the business. If you are operating a fleet of buses on certain routes, versus if you are delivering food to households, and versus if you are delivering enterprise IT, there may be common elements across contracts that you would be seeking to protect, but then there may be very, very unique or different elements. So I think I would say that at the outset, before any processes are actually thought, the founders need to be very, very clear that how should they organize their contracts so that minimum protections are obtained. And in this journey, I think here Roopa can also weigh in. They will need professional help because this is a complex subject. So Roopa.
Sure. Thank you, Dipankar. I completely agree. So I also want to highlight to our viewers, two things. So just because it's all of legal jargon, don't think a contract is just legal. Right? Every aspect of your company is pretty much in a contract. Most important, of course, your VCs will want you to do top line. Will basically, even before they start talking to you, they're going to ask you, what's the sales trajectory looking like? And when you're doing that, very important is to also understand when you sign on to something, how is it going to also probably affect your pricing? Okay. So this is very integrated. It's not just the legal risk and liabilities, but also the pricing. So when you're managing these contracts, you are looking at, and I think this is very well done by the founder, because at the end of the day, founder is driven by money coming in. And a lot of times risk and compliance, and I think, as I said, again, that is changing now, but risk and compliance seems to be taking a slightly backseat to, I want money in the bank. Okay. And that has been changing, as I said, again. So when you're looking at, let's say you're entering into contract, let's say you're a services company or you're a product company, when you're agreeing to things, right, whether it's a license agreement or whether it is a services agreement or whether any agreement, when you're agreeing to things, there are a lot of hidden costs in there that could affect the pricing. So when you're managing contracts, you're looking at what you've committed to, what not only on the legal side, but what effect what you've committed to is going to have on the financial side, i.e. pricing the product or pricing the service. So that's just one additional thing I wanted to add. Yeah.
Maybe the two other things that I would like to point out. I think what Roopa covered now and what I said in the beginning are very substance oriented as to how you think about your contracts. And I think there is some process oriented points that I would like to mention. I think it's very important for startups to, even when they are at early stage, start thinking about how they are storing and managing their contracts, because contract numbers can increase soon. And you may be signing on contracts without even realizing every time, let's say you're subscribing to some online services, You are, as I said, you are bringing in some consultant. There may be multiple contracts that you're signing. You are signing an NDA with your customer. You may be signing agreements with experts. So, in good 6 months to 1 year time, after you have actually been in business, you may be accumulating contracts. Some of them may be only short term, some of them may be long term. So it's important that you have a way of putting these contracts in a place that you can find them when you need. And I think in my experience as a lawyer, I've seen this many, many times, that people, when they try to look for a contract, that they don't actually find it, because this is because there may be so many other documents, and generally you don't remember where you have kept the contract. You may not have scanned them. You may have only kept them in your drawer, and you can't find when you need this. And if you can't find when you need a contract, and believe me, about half the time people do not find their contracts when they're looking for one. And this is a study done by PwC. So it's important that you establish some early hygiene by starting to store contracts at a designated place. Now, this designated place could be a storage where you have easy access to. People do it in Dropbox or in some other form where they can store, or it could be even more specialized storage where you can find the contract more easily than when you file it with Dropbox. But leave that for the moment. The message that I'm trying to send is that as soon as you are 10 contracts strong, start putting them at a place so that you are able to find information from within those contracts when you need them. This is something that I would highlight as a process point. And the second process point that I would say is that if you think that you will be signing contracts which are repetitive in nature, then you should create templates. For example, as Riverdas, we had subscription agreements which we signed with every customer that came and subscribed to our knowledge services, or our knowledge portal, or our research portal, and every one of them had to sign a subscription agreement, a template of which was generated. And it is important that you can create the final contract from the template very, very easily when your customer has actually agreed on the commercials, because it's not good that the customer has agreed on the commercials and you are taking a long time to deliver that contract. So I think, from the process perspective, other than setting the boundaries of, other than the substantive boundaries of what are your risky areas of contract, you should, from the process perspective, think about repositories, contract repositories, and setting some templates for repetitive contracts which are important for your business. And Roopa, maybe, or Juieen, you may come here and give some perspective on that. Processes do have an impact on how the startups will actually grow to become a mature company at a later stage.
Yeah, I was just thinking about that too. So whatever you're putting now, as I said earlier, a company would get acquired at some point and everybody's running helter-skelter trying to find contracts. So now that's not true for startups. Right at angel investment, right at early pre-series A, series A, you are going through scrutiny by your investors who have responsibilities, from their partners, from their investors, or even sometimes it be from the government through the Startup India Action Plan. So this has to be taken seriously. And another thing that India has, Dipankar, for you, and I don't know what it is, the signature law in India is a little different, right? So when you can store your soft copies in your online boxes, there's also another thing that we need to take care is the hard copies, where you have physical signature. People are working on regarding that on the on policy level, and hopefully in another few years that will get resolved. But right now, Indian startups or Indian companies have to look at both, because contracting is you need the hard copy signature, that's foolproof, and also you need the soft copy for businesses to continue to do their work, so that we do it faster because of the way we work remotely. So that's my 2 cents here, Dipankar.
Thank you, Roopa and Dipankar. I think the messaging is clear that, like Roopa says, from a substantive perspective, understand the bargain that is being captured in the contract. And Dipankar said that processes are as important as the substance. So have a framework, have infrastructure so that, what you have commercially agreed is retractable, or you can access that when the need arises.
No, sorry, I won't be doing justice, Juieen, if I didn't talk about customization. I will come back to that a little later in our, discussion. But right now, templates are very important as and when we start doing things more than once, if you're doing the same thing. But that doesn't mean everything can be templatized. And we'll talk about that a little later.
Correct. Now that we have contracts in place, we have processes, which will keep them in a retrievable manner. I thought, let me, come to one of my favorite areas.
Yeah, I was just thinking, are you just going to keep asking us questions, or are you going to, get some bullets in you too?
I thought, you have contracts in place. And I think for a startup, one of the most important contract is the founders agreement, or you have contracts with your employees, you have contracts with third parties, and then a conflict arises. How should startups look at resolving the conflicts? Now, before I get into the resolution bit of it, it'll be good for me to understand with all of you, and maybe you can, if you would like, you can put in your chat as to what you feel about startup conflicts. I think one thing, with time we have realized that conflicts are inevitable. It is not that it is able to probably prevent conflicts or probably delay it, but conflicts at some point in time in our lives, we cannot avoid conflicts completely. So we must have a mechanism to address it. Now, why are I feel that startup conflicts are special. And that is because if you look at a startup and at any point in time, if a conflict has arisen, that conflict, if not resolved properly, could have the potential of making or breaking that startup. So it is not the conflict which is so important, but how we respond to the conflict becomes very crucial in the journey of, in the go forward journey of the startup, so to say. And if you look at probably founder conflicts, I think they are really nuanced and very special because of the amount of emotions which are involved in that founder conflict. I mean, for a moment, leave aside a conflict between me and Dipankar, because we will have many other, ancillary litigation as to divorce petition and custody battles to fight. But even amongst unrelated founders, I would say that conflict is very, very, special, because the circumstances in which that conflict has arisen. If we look back at what these founders would have done to get to the point where they have a conflict, they would have invested a lot of themselves at a compensation which probably is not optimal. They have gone through different kind of emotions at different points in time, had to fight different battles. So it is natural that when there is a conflict between the two people who have held the baby together, that conflict becomes special. And unfortunately, our response to conflict today is adversarial, which means that we want to go to someone who will tell us you are right and so is wrong. What I feel that adversarial dispute resolution does not allow is a safe space for people to reflect as to why that conflict is special, and what to do, how to make those two oranges out of one orange, how to ask the question, what was the vision and mission. So a startup conflict is very special in terms of how it should be treated, and an adversarial mechanism does not allow that space. And therefore I'm here to speak about mediation, which is a collaborative method of dispute resolution. What is mediation? Mediation is, and we have had fantastic clinics from CAMP before, and we have, talked about this in detail, but, just for the sake of repetition and summarization, mediation is nothing but facilitated negotiation, where the parties voluntarily come and find a resolution from within. So, the three pillars which are very, very important to mediation. First is the fact that it is voluntary, that, you have to decide for yourself as to whether you want to come for mediation or not. And there is nothing, even at present at law today, which forces you to mediate. So it's a voluntary decision. The resolution that you get at the end of the mediation process is self-determinative, which means that you for yourself have decided what is the business resolution which works best for you. So you have had time to think about the conflict. You have had time to think about the repercussions of the conflict. You have had time to think about, what would happen if the conflict did not resolve. And you have been allowed that space by the mediator. Many people ask me, that, why do you need a mediator in a mediation? I mean, I negotiate my conflicts every day. Why do you need a mediator? And to illustrate this, I really depend on the story of the camels. And this is a story from the Middle East. And William Ury, who started the program on negotiation at Harvard, he tells it brilliantly. I try and emulate, but please stop me at any point in time if I'm not clear. So basically, the village elder, the rich businessman, he's died, and he's left behind a will, 3 sons, and 17 camels. In his will, he has said the oldest child gets half the camels, the middle brother gets 1/3 the camels, and the youngest brother gets 1/9 of the camels. The brothers are fighting day and night. They just cannot divide the 17 camels by either 2, 3, or 9. So finally, the eldest brother decides that, we will get rid of the camels, we will sell them off, and the money will be divided in this proportion. That is possible. The youngest brother is not agreeable to this solution at all. And he says that, no, whatever the father has said, we must, abide by that. And I don't know how you will do it, but I want my 1/9 of camels. So after all of this fighting, they finally go to the village, old wise woman of the village, and say that, oh, look here, I have 17 camels and this will, which says it has to be divided in half, 1/3, and 1/9. The old woman, she asks a lot of questions, tries to understand interest and, why they're doing it. And finally, even she can't find a resolution. And she says that, well, I don't know what you will do, but if it helps, please add. I have 1 camel, you can add it to this group of camels. Now you add another camel to the 17 camels, it becomes 18. And 18 is divisible by 2. So the oldest brother gets 9 camels. 18 is divisible by 3 also. So the middle brother takes 6 camels. And the youngest brother takes 2 camels. And if you add 9, 6, and 2, it is 17. Actually, the old lady gets back her camel. So it is very important that, we find that old lady, or, I was reading an article by Sachin Malhan this morning. He calls it the right elder as the mediator. So what the mediator will do, because she is trained to create that ground for, that safe dialogue, that conversation, that reflection, that she'll create that safe environment where people can come and reflect. Because many a times, when we are in a conflict situation, what happens first is that communication is the first victim. So we stop communicating, we stop talking to each other, we are arch enemies now, and we will not speak. So the mediator, designs the process such that the parties reflect, understand, and then start communicating with each other. And like we have all seen in different parts of our lives, once you start communicating, solutions start coming up. And from one orange, when you ask the question why do you need it? You need it for the pulp for juice, and you needed the the cover for your baking. You make 2 apples, you come up with a resolution which works. So therefore, I believe that in startup disputes, startup conflicts, where there is so much emotion, so much of, there is so much to say in those conflicts, unless we provide that safe basin where people can come and dialogue, find a resolution for themselves, we are probably not doing justice to that conflict. We are not converting into an opportunity. Each conflict is an opportunity to create something new. And if we go for the adversarial mechanism, we are often destroying the value. We are not creating the value. So my suggestion to startups, and and at different points in time, we will come with different conflicts. First, try, discuss, and at regularity, take feedback to understand that if there is a conflict which is brewing, but even after all the preventive steps, it is possible that you are not able to avoid a conflict. If there is a conflict, embrace the conflict. Find a resolution, find the right mediator who will be the right elder. And Sachin Malan says that the right elder need not be older. He may be or she may be a specialized person who's able to create that safe environment for you to come and speak. Now, CAMP is doing a fantastic job of, having an aggregated list of very specialized mediators who understand the issue and who are able to create that safe environment for you. So I think, my 2 bits on this, 2 startups, is that conflicts are unavoidable. Embrace conflicts, find collaborative ways of resolving conflicts, embrace mediation. I think with that, I would like to pass on to Roopa and Dipankar, if you want to add anything, Roopa.
So yeah, thank you, Juieen. Yeah, I've been a general counsel for some time, and I've worked with startups for several years, as I told you. And there was something missing for sure. Okay, and that's when I also found CAMP. So I'm also a trained mediator through CAMP, and ever since, but I haven't mediated. I think I joined more in terms of trying to find a solution for a real solution, right? Because there's so much effort and time that goes even in arbitration, even and the formal systems that are existing right now. And people go to court, then you're all, it's not the right way of using your energies during startup phase. So my thing is, once I started understanding more about mediation, I've started including the mediation clauses in my contracts. In almost all contracts I've drafted ever since I got exposed to mediation. There is a mediation clause, and a lot of times, obviously, it's CAMP, because in Bangalore they're a real solution, and it's a safe place, as you rightly said, right? When you're not agreeing about anything, when you agreed about a forum, then you don't have to think so much. You go there. It's a pretty mature way of thinking, of identifying there is an issue, and then going and actually resolving it. So the first step to not have an issue is actually have a contract that actually speaks about all the different aspects. So that way you don't get, even if there is an issue, you identify it and you go back to your contract, then you agree with whatever you kind of identify whatever you agree. But let's say, even as you said, after negotiation, you're not able to put it through, you have a straightforward, safe place here. And, and I don't see any reason why, commercial mediation should not take off like the way it should right now, because it is and this came to me a little more when there were conflicts happening. I don't remember which one, but I think it was the Stazilla case a few years ago, when there was a conflict between the founder, the company, and their vendor. And don't quote me on this, but I'm sure there are other similar situations where it just escalated and the founder was put in jail, right? So these are commercial disputes. I mean, there is no reason for things like that to happen when there is a easier and a much more straightforward way of pre-litigation process. And I can't think of a better way than the structured mediation process that has been put in place over the last few years by the likes of Laila Olipalli and the others who are in the forefront of mediation. So we need to take care, or it would be great if more of us are able to advise our clients in using mediation as a first stop. It is also getting a lot of buy-in from the policymakers themselves. But this is the way to go, more so because of the kind of litigations and the caseloads that are present in our court system. This is the straightforward way to go. It's a structured way. Plus, it has it basically, you come out a win-win, and which is what a contract needs to do. A good contract is a win-win, and so is mediation.
Thank you, Roopa. So with that, we move on to our next question. which is, Dipankar, maybe you can start with this. What are the top 3 things which you would want startups to keep in mind while contracting?
I think every startup and given every contract situation, the first thing to understand the goal from that commercial bargain, and to understand the respective position of the parties and to what extent they are able to influence the course of the contract. There are some givens in generally in negotiation, contract negotiation. I'm no expert of any other negotiation, but in contract negotiation, I've generally seen there are some givens. For example, if you have to borrow money from someone, then the person who gives you money has an upper hand. At some point of time, giving financing to pre-seed stage companies could have been described as a situation where the financier had, or the venture capital fund or the angel investor who was investing had an upper hand. But now, of course, companies have so many choices that they may also be pushing back on certain clauses. So, but given any situation, employer-employee, generally employers have an upper hand. So, and then there are some which could be very evenly negotiated. It depends on, if you are a purchaser of substantial quantity of something, and the other side is also a similarly positioned startup, then you may be dealing with an equal, then there could be, much more scope. So important to understand early on, and this I think founders do understand, that what is the goal that you are trying to achieve from the contract and how much of leverage you have. If you know this well, then the contracting process will go well. Then there are certain things that you will have to be there in the contract and to be aware of those, and where you are not aware of those, to find a process by which you can become aware of those. And then the third thing is that the commercial bargain has been adequately captured, and you have a process of resolution should you hit a roadblock while implementing the contract. These are some of the things that come to my mind when you are about to enter into a contract as a startup. These are true for larger companies also, but larger companies often have resources in their disposal where somebody actually sets this path correct for them. As a startup, you got to be conscious, at least for some initial years maybe, and then of course you will have people who will set this straight for you internally and in-house. Roopa and Juieen, you can also add to this.
So I'm going to wear 2 hats when I'm going to speak about this. First hat, I'll wear my lawyer hat. Okay, so whenever I advise startups about contracting, the first thing I would say is, or when I would review on behalf of the startup, first thing we do backwards. First, check the dispute resolution clause. That's where you begin. So it's extremely crucial, and this is more crucial if startups are entering into contracts internationally. I'm comfortable about the US, so I can talk about the US. If you are, whether it is for investment purposes or for sales purposes, you are setting up an entity in the US, and you're starting to contract with different states and companies with different states in the US. US law has contract law, so basically 50 states, 50 contract laws, unlike in India. In India, it is one contract law. The main Indian Contract Act applies across the board, and interpretations, while it's almost similar across India, but you have in the US, it's completely different, right? So I always advise startups with international reach to standardize the dispute resolution clause as much as possible. If it's in the US or in Singapore, you have the equivalent mediation clauses there, and you invariably, if you're the vendor and the customer sits there, you'll probably have to give in to the other country's law, unless you're able to negotiate London or something. But otherwise, if you have a product and you're licensing it and you're an Indian company, there is no reason why you can't have Indian law governed. Okay, so it all depends upon the negotiation power between you and your contracting party. So depending upon the stage of contracting you are. So as a startups, maybe you don't have too much negotiation, but what you can do in your limited power, put those processes in place when you negotiate, right? So you need to look like New York law versus California law. Is it an employment contract? You need to be careful. Obviously that has to be local law. If it's a commercial contract, Texas law versus New York law. Like, do you have a place of business in the US? Do you have a good standing in one of the states in the US, or are you a Delaware registered company and are you just beginning your operations from India? So these are all the different nuances that come in when you are an international startup. And just because, obviously, my experience with startups is a lot of times, even before seed investments, you probably already have an office in the US, or if you're doing APAC, then in Singapore. Okay, so this is very crucial. So these are the most important is that from the legal hat, from the business, from having been an entrepreneur over the last few years, and also a general counsel. My perspective is slightly different when I look at a contract wearing my pure legal hat versus a business hat. When I'm reviewing a contract with legal eyes, I just redline. Okay, I make it look good. I redline. I make all the clauses that should be highlighted. But when I wear my business hat or my general counsel hat or a business lawyer hat, and if my startup says, "Hey, look at it more from and get the deal done," right? That way, then you're talking about, hey, you need to walk away win-win. There's no ego here. Okay, this is a very philosophical approach here, right? You are talking about win-win for both parties. And at that point, it's not, hey, I got 1 point over that other lawyer. You're not talking that. You're talking about making the deal happen. And there is always finding that equilibrium or that spot out there where everybody goes away happy. And that will take us, so on the screen, you can see risk appetite. So there are various aspects to that. What is the risk appetite of the company? Okay. Comes from the board, comes from the founders, comes from certain contracts you've agreed with your investors, comes from various aspects there, right? So what happens to, how far can you go? How far can you push yourself? Okay, there is a warranty that the other company is asking you to give a particular indemnity, which is basically if you guys don't do something right, then you you pay for it. And then the lawyers will have all kinds of permutations and combinations. So the point is now, what is your risk appetite? Do you have insurance to cover that? Something goes wrong. Are you even able to give that promise? Are you able to take that risk? As a lawyer, I'd never say that if you can't, I would always say if you can't align, don't even sign on to that. But as a business paper person, I'm like, okay, maybe you can take that risk. Maybe, we'll never get there and keep our fingers crossed, right? So negotiation part, do you really need that contract? Do you really, really need that project? How much money are you getting? Is it really worth it? Are you getting into a country where you don't know what is, you don't have sufficient finances? Like I know people, specifically, I have a family experience where somebody I know went into the Middle East without even knowing, what the law, especially Saudi Arabia and places like that. Today, people have help when you go into different new countries. But they came back, where, the company went into bankruptcy because they didn't handle it right in the beginning. The contract negotiations and the win-win did not happen at every stage, right? So, so that's my 2 cents here, where, you wear the different hat depending upon, I know there's a mix of lawyers and entrepreneurs and ecosystem players in this particular group. So depending upon which hat you're wearing, you will be looking at it from that particular aspect. And the point is get the deal done, and make it happen. Identify, and the contract should basically be not a document that you just sign and forget, right? It should be a working document that helps us through the whole process, through the business, and actually helps you resolve disputes even before it starts. It will become the guiding point of, how you take it forward, how you take that particular business relationship forward.
Thank you, Roopa. That is very, very helpful. And I think the thrust of what you said is that understand what you are getting into, understand your risk, understand your negotiation power, and accordingly calibrate and get into the relationship, because it is a relationship that you're getting into. It's a contract that you're getting into. Give it the weightage and the importance that it requires. I think that's a very, very clear message for startups. I have sorry, yeah, Roopa.
No, I was just saying, and it's okay to say no. It's okay to walk away.
It's okay.
It's very tough, very, very tough, And from personal experience, I know the two of us, when we were talking about stuff, And that is the important. It is important to go through that process in the beginning. The more you are negotiating and discussing in the beginning, the easier it is as you go along, right? So that is the important part.
Right. Right. I actually have a question for Dipankar, and that is related to the second point, which is, and Dipankar, in your earlier conversation, you said, how, if you are using a contract repetitively, templatize it. Now, many a times as startups, we don't have the leverage to, follow through our templates, even if we do have a template. Now, in light of this, what is the importance of a template? And why should I, expend money and resources in templatizing? And, how will it help me in my contracts with third parties where I am not being able to use my template?
Well, I think in so far as the third-party contracts from third parties are concerned, of course, the templates that you put in place cannot directly be helpful. But when you get any third-party contract, the important part that you have to do actually is to make sure that the contract does not have any unwarranted risk that you have not signed up for, and the contract also reflects the commercial bargain that you have signed up for. So I think what's important in a third-party contract is because somebody has drafted this contract, so they are not expecting a large-scale change. Like Roopa said, you would not be possibly doing a full-scale change of that contract, but you would be doing a review of the clauses to make sure that is there any risky element in this clause that if you agree today, you will have difficulty in implementing, or you may have other difficulties in future. I'll give an example. For example, you could have a clause which says that if you delay delivery of certain things, then there would be certain kind of daily penalty charges that will apply. This kind of clauses can stay deeply hidden inside a contract, inside languages which may not have a particular heading by which you can quickly identify. So it's important to do a risk review of third-party contracts, and to make sure that those contracts are of a particular standard that you can accept. It means when you get a third-party contract, you are not looking to change them from head to toe. You are trying to make sure that the content is acceptable, palatable, and it does contain the commercial bargain that you have achieved. So this is how I think the approach to the third-party contract would be there.
So I think, Dipankar, you are saying that, risk review your contracts vis-a-vis the templates or the positions that are your positions in your templates. So basically use that as a goalpost to see what you have agreed and whether you are able to, agree on this third-party paper. And this is read with, Roopa's suggestion that there could be certain things which you need to walk away from, and don't be afraid to walk away from those aspects or those contracts. Roopa, I know, earlier in the conversation, you had mentioned that you had something to add when we were talking about templates to customization.
Yeah. So basically, it's important, as Dipankar said, if you're doing the same kind of contracts, again, it is important to have standard clauses, standard dispute resolution, standard third party, the entire miscellaneous clauses, and some of the structures that can be standardized. But there is no standard contract. There's nothing called a standard contract in life. Some people might say, and I've been part of several groups, and people will say, hey, can I just have a template? Can I just have the contract, that you've done with in relation to this, But that is dangerous. That doesn't work. Every contract has to be customized, to whatever is the business at play at that point. It could be anything. It could be as simple as an NDA. Yes, you can start off with an NDA with a template, NDA templatized NDA, and that's a good idea. Okay, but after that, it is about, you have to review what is confidential information. Are you the person receiving confidential information? Are you the person giving confidential? The standard clause will be there, and there will be a catch-all saying and all other. But there's nothing like actually customizing it to whatever you are actually disclosing. And this is more so in a highly, if trade secret and highly you're a highly IP oriented company, it is important for you to specifically state, okay, it could be, yeah, so it specifically states. So this customization plays a very, very important role. And I don't know, Dipankar, whether technology has come to that level where, you can, you still need the human element, you still need that human brain, right? So that customization is extremely crucial in making sure that you are able to put in your positions out there. And also, to be fair, I think lots of technology also come in for which position to some extent of customization. But the final thing has to be done. It's the sixth sense of the founder of the company.
I completely agree.
So thank you, Dipankar and Roopa. I would like to spend a few minutes on the dispute resolution clause. And I think, Roopa, you did mention that, when you are reviewing startup contracts, you oftentimes suggest that they look at from backwards, right? Where your dispute resolution clause or a governing law clause is at the fag end of the contract. In fact, that's something that happens to not only startups but to well-established companies. That we do not pay often enough importance to the dispute resolution clause. And probably I feel, and I think there is enough literature. One is that, if you are doing a huge negotiation on a contract, then the dispute resolution clause comes, at an hour which is unearthly, and all points have been thrashed out, and you are ready to click your champagne glasses, start the new business relationship. So dispute resolution, I think, is not even, in the list of things that you would want it to be there. So therefore, dispute resolution clauses are not given enough importance. I read some study somewhere where they said that most dispute resolution clauses are copy-paste, but it is very important to understand, like Roopa said, that what is in the governing law. Should the governing law be of a particular country? Am I able to get the legal remedies in place with that governing law? Also equally important is to include a mediation clause, like Roopa said. And what does a mediation clause do? One is it brings mediation, which is not often used, in the spectrum or the landscape of dispute resolution. So when you do have a conflict or have a situation, you would many a times you would go back to the contract and see, what does it say? What should I do now? And if you do have a dispute resolution clause, which is a mediation clause, you would first want to mediate. You will see that, okay, now let's go to camp, let's appoint a mediator, let's get this process done. So it brings mediation in the discipline of dispute resolution. The other thing which is very important is that and Roopa and I were chatting a few days back, and she said that, where are we in terms of people feeling that if I suggest mediation, I'm the weaker party, right? And this can naturally happen in a startup where, the startups are growing, young companies which have a lot to prove, and they have a dispute at hand, and you are suggesting mediation. If you have a dispute resolution clause in your contract, which already has mediation as a method of dispute resolution, you're probably just following course, right? This is what the contract, at the time of entering into the contract, you envisage to do. So therefore, there is no qualitative assessment at that point in time as to whether you're the weaker party or the stronger party. Whether or not there should be any attribution of weakness to someone who suggests mediation, is a question for another day, and we will discuss at length. I do not think it is. But bringing in that mediation clause in the dispute resolution clause in all your contracts actually opens a new avenue in case of a conflict resolution. So do look at your contracts, do include a dispute resolution clause which suggests mediation. I know at camp we have gold-plated mediation clauses. So do reach out to Surya, to me, or to anybody else, and we can help you with that dispute resolution clause. Now with that, I see there are two questions which have come on the chat box, and we will address it in a short while. I'm cognizant of time running out as well. But having known that, we must, as startups, put processes in place. We must, as startup, look at contracts substantively. My question to Dipankar and Roopa is that we know that at startups many a times we are reeling under the constraint of time and resources. Now, are there solutions available for startups to access time critical, cost efficient assistance for their contracts? And what are these solutions which are available and which they can avail at a time when they are negotiating a contract? Maybe Dipankar, you can start.
Well, I think the sense of all that we have discussed, if I have to sum up in one or two sentences, is that if you are entering into a contract, you know your risk well, and you make sure that your risky areas have been addressed well in the contract. This is the sum and substance, and this is a very complex goal to achieve, because the contracts are written generally by lawyers, and the language of the contract is not always plain simple English, although that is the goal. But sometimes lawyers tend to write complex language. Sometimes certain concepts have to be written in little complex language. But given that there is complexity involved, I think where technology and human element can collaborate with each other, the technology today is very good in sort of understanding what's within a contract and listing out that content against certain standard risky concepts. What I mean by that is that when you take a contract, you possibly have about 15 to 20 risky areas within the contract, or high risk areas within the contract. Risky areas sounds a little not correct, but high risk areas, meaning these are high impact areas which you have to focus. This could be, things like how long is the business relationship valid, how can the business relationship be terminated, whether it can be terminated by one party or whether it can be terminated by both parties. Are there any impact if the business relationship is abruptly terminated before the term of the contract? This is one type of, continuity related high impact areas. Then there can be certain payment related areas. What is the amount of payment? What is the payment terms? If somebody defaults in making payment, is there any consequence? So on and so forth. And then there are some legal or compliance related areas. People could be made responsible to pick up certain costs. They may be made responsible to take some permission if they want to do certain things. For example, surprisingly, I have seen in completely unrelated contracts provisions that one party shall not change their shareholding during the tenure of the contract. This was not a fundraising contract. This was some strategic collaboration contract, and there was a stray clause which said that one party will not change. With that kind of clause in place, raising financing can be difficult because you may have to go and seek consent of the counterparty. Then there could be, as Juieen said, that there are certain clauses relating to dispute resolution or conflict resolution in the contract. So in all, if you see that there may be about 25 to 50 high impact clause types that reside within a contract. Now, technology today is very, very good in identifying them within a few minutes of actually receiving a contract, and sort of scanning that, understanding the natural language within that contract, and then sort of summarizing for someone who is concerned with the contract the main high impact or risk areas of that contract. And I think from here, how to deal or which one to prioritize within those high risk or high impact areas, because some of them may need not be addressed, some of them may need to be very quickly addressed in order to move forward with contract closure. I think there is a strong human element that come in place, and I will leave Roopa to speak of that element, but I will summarize what technology can do today. If you have a contract that you want to very quickly understand what is the risk in that contract, the technology is today able to sort of generate a quick overview of high impact, high risk areas of that contract within a few minutes of you uploading that contract within certain types of system. But of course, from there, you need a strong human element. And I think therein, Roopa has some good perspectives to offer. And Roopa, over to you now, where it can go from there.
So having been in this situation for so long, I've always wondered, and I've been a lawyer, and I'm sure the lawyers in this group will agree, it is very frustrating to do the same thing over and over again. And thank God now we have technology coming in, such as, what you've developed also, where you have, it makes the human's job easier. Okay. That being said, you have the technology, you put in the contract, you get your summaries, but then it is a human who has to come in and use that, the next level and their expertise. So basically, going through law school is not wasted. Okay, you still need that. Okay, it's technology is never going to replace the lawyer. Okay, and we are not there. We are not that, technology, and I don't know if I can use the word neural networks. We haven't reached that level of sophistication of the brain, and I think at least not in our generation. And it's also not required. It's a problem to be solved. It's not a problem to be solved. So we have enough humans who are, at least in India, who are able to provide good, sophisticated advice. And this has been my journey. I just want to quickly put in the journey over the last few years for me, and I've been part of, TiE also trying to do this, where we have actually, there are lots of startups who need help. And there are a lot of very sophisticated lawyers who are able to provide cost-efficient services, who are part of the gig economy. And I need to bring that word in because we have it on our topic. So basically, India is filled with independent lawyers who are very sophisticated, and that mainly in the litigation side. Over the last recent years, you have a lot of corporate lawyers too, who are available to do your contracts from, I have to use this word, a little cliched, but from remote locations. Okay, and so these are sophisticated lawyers who worked with, larger firms who probably decided that they would rather work in a different structured setup, in a different setup. And so there are smaller firms, there are medium firms, there are independent lawyers who are extremely sophisticated and who continue to work from from different locations. They are able to provide very, very cost efficient services. So we at Flywork, we've been aggregating a lot of lawyers. Personally, I used to do that in my own law firm that I founded before my Flywork avatar. It was a small practice. And it's fascinating to see how we are able to provide low cost, but not a very quality and efficient services using the gig economy folks. Right, and now you add technology, and how much more powerful can it be? So that's the message we wanted to bring across, saying that there is a solution, that there are options available for startups should you choose to do the right thing. Right, you don't have to get flustered about big law, who sometimes you may not be able to afford immediately. And then there are good, sophisticated lawyers available there who are ready, willing, and able. And the important part is try to make the match and make sure folks are represented, and you have a better business and a professional environment going forward within the startup ecosystem. Yes. Yeah. So Juieen, back to you.
I think I just want to add to what Roopa said, essentially combining between what I said and what Roopa said. One practical way that we are sort of seeing technology and human element coming together. Riverdas as a company, of course, does the first part of what I explained. I mean, we are able to bring any contract onto our platform and within a couple of minutes generate a summary of very high impact areas within the contract. This contract could be 80 pages long, 100 pages long, or 10 pages. It really doesn't matter. It could be a consulting agreement, it could be a services agreement, it could be typical business agreements that a startup would possibly be signing in their early years or even in their middle years. And what we do is that, along with the beautiful platform that Roopa has built, and with her co-founder Shri Roopa at Flywork, we try and bring this technology and human element together so that we can actually help startup companies to very quickly understand and respond to their contract creation needs or contract review needs. And I think this is unique in the sense that if you really look at the technology, it can go today very deep within a particular text and classify that text in whether it's risky or not risky, but it cannot really do it as good as a human can do. But again, I think where the innovation comes in getting how quickly you can have that human expert on board so that they can understand and they can reflect on what the system or the machine has done. To bring all of these elements together, I think is the beautiful part of this whole initiative that Flywork and Riverdas is taking. And I think, as Roopa explained, given we have very, very smart lawyers and they have found the right way to bring them on board to solve a specific problem. I think we have today solutions which startups can access in order to address their contracting needs.
Thank you, Roopa. Thank you, Dipankar. I think that's a strong message that for startups for whom time and money are very, very important resources, there are solutions available where the smart Flywork lawyers can become smarter with Riverdas, tech solution to provide you timely and cost-efficient services. So I think that is all that we had planned in the discussion today. If anybody has any questions, please feel free to put it up on the chat box, or just raise your hand and ask the questions. We already have 2 questions from Shruti, and her first question is, as a startup, how do you resist the temptation of closing a deal quickly if elongated negotiation would mean driving the other party away?
Yeah. Let me take that, then you can take the next question. Yeah. Hey, can you hear me, guys?
Roopa, we're not being able to hear you.
Can you hear me?
Yeah.
Okay. So yeah, this is a extremely crucial thing. Having been in the startup on, like, I've also faced this. We've also faced the same question, right? How do at what point do we say enough is enough? So when I advise lawyers advise companies with the general counsel hat on, at the end of the day, we have 15 points, let's say. But really, the deal breaker would be, if at all, 1 or 2. So you literally have to work your way through. It depends upon the time and effort and what commitments you have given to other people, and that you need to, like, for example, if you are working on with a product, you're a product company, and you have licensed software to be part of that product, right? You are only able to give what your licensors can give you. That's non-negotiable. You can't even do anything more. So if your customers want something more, you can't even do it, right? So at that point, there's no point saying you can do it, because then you'll be in an IP infringement situation, and that's not good, right? But that being said, if you're talking about clauses, as far as I've been told, and this is something which even during my general counsel days with larger companies, nobody walks away from deals because of legal. Usually deals you walk away and it doesn't make financial sense. Okay, legal is there to protect you. Legal protects you and the risk. So let's say you have somebody asks you to do, I don't know, Shruti, if you're familiar with contracting, one of the places where people really get stuck is in the indemnity clause. Okay, and the worst clause that no lawyer likes is unlimited indemnity for breach of contractual obligations. I don't know if, that is the worst. And that is, for most places, at least larger companies, that is a deal breaker. Okay, so as a startup lawyer, you're in that situation. Okay, and how are you going to, or a founder, you're in that situation where it's a take it or leave it. And your other you're contracting, your customer is willing to pay you the money, but needs you to sign on to a clause like this because they don't trust you, because you're a startup, right? So, at that point, business comes in, you protect it with other clauses, right? Yeah, thank you. Yeah. So basically, you protect it with other clauses. You say, okay, that's fine, but there's a limitation. You have to identify. That's why you have the smart right lawyers in there, right? So to give you all the 5 or 10 exceptions, and then you see, yes, you have to sign the contract, but the lawyer's job now is to make sure a business is going to sign the contract. The founder is going to sign anyway. How do I make sure that they are not in default? Right? How do I make sure? And that is where the expertise comes in. That is where templates, that sophisticated templates come into play. and you have to make it work. That's it. And trust me, if somebody is talking to you, they want to do business with you. Okay, it's not that just because they're a big company, they're there to screw you. No, I mean they are. If the fact is they've gone through sales, so the sales guys are the main people who are going to get themselves into ashes, right? By the time it comes to legal, by the time it comes to contracting, the business has already made up its mind that they're going to spend time and energy making this happen, right? So just make it happen. That's it, and that's where you have. So now it's about protecting the risk. It's not about, yes, are you going to do the deal or not? That's already done. It's finished. By the time it comes to contract stage, you already got the deal. Now it is about how you're going to smoothly make it happen and actually understand what your risks are and provide for them. And that is where you have general counsel of larger companies making it happen. And today you have enough and more general counsel for startup to help you make it happen. Shruti, does that answer your question? Or if you want, I'm happy,
yes,
Shreya can give you a contact.
Yes, thank you. It does. Thank you.
Yeah.
No, I completely, sorry, Dipankar, you're saying something?
No, there is the other question on smart contract. Maybe I can quickly answer that question. Yeah. Essentially, smart contracts are not contracts. They are basically logic which can self-execute. And smart legal contracts are actually provisions of contracts which are written in prose, but then converted into algorithm, which can self-execute a provision of a contract. So smart contract can be used in the context, in many other contexts, where you have a logic or a condition which can self-execute itself, meaning, a particular condition, if it is met, then a particular consequences will flow. And the smart contract can actually assess whether that condition has been met, and the consequences can then ensue, all on autopilot. A smart legal contract, which I can give an example, is that where if you have a payment to be made, provided certain goods are received by certain parties, and if this is written in contract in English language, and you would have converted this into an algorithm, provided a fail-safe mechanism, meaning an undisputable mechanism of proving goods have reached someone. Maybe it could be a challan at the factory gate. Somebody uploads that challan, the document gets verified, and the payment is automatically debited from the bank account and credited to the seller or the supplier's bank account. This whole process is actually a smart legal contract, where a prose in the contract, when I mean by prose, is a clause in the contract which would have in 10 lines described what will happen from the time of delivery of goods to the payment, has actually been converted into a series of steps that the computer can execute, and that's smart legal contract. So I hope I have clarified smart contract and smart legal contract. Smart contract is more generic of any self-executable condition, and whereas smart legal contracts are where you're converting provisions of contract into self-executable computer algorithms.
Thank you. Just a follow-up question. Do smart legal contracts have any advantages over a regular written contract? What we understand as contracts usually?
Well, it has many, it can have many advantages. It basically takes away the transaction failure possibility to zero, meaning thereby there is no discretion involved. Transactions will be automatically executed by machine. It also means it has to have objective, very high level of objectivity. For example, in my case, I was saying that goods have been delivered. Now, as you realize, if these are very simple goods, let's say, you're buying something, like say pens, and these pens are very easily available. There is no particular quality standard. These are Reynolds pen made by Reynolds manufacturer, and they are delivered at your factory. Then there is no discretion actually involved. If you can show somebody has received 500 pens with a receipt, then that could be a proof and evidence basis which the whole thing can be executed. So the benefit is that, there is no discretion. It can go very fast. Money can be collected very fast from the purchaser, and the entire thing can be in autopilot. It's dispute proof. There is no question of any dispute over here, because if the conditions have not been met, the computer will not execute the algorithm. However, if you have some certain types of goods where quality has to be checked, verified, then this kind of smart legal contracts will need many other conditions to be embedded. So in a highly subjective situation, you cannot actually have smart legal contracts, or you may have smart legal contracts, but the complexity increases. So benefits are many, but also areas of applications have to be chosen carefully.
Thank you.
You're welcome.
Juieen, I have one question.
Yes, Surya, go ahead.
Yeah. So I would like to know how Riverdas helps in managing contracts with regards to the contracted deliverables.
Well, do you want to answer that question?
You go ahead, Dipankar.
Sorry, if I understood that question correctly, what Riverdas does is that, it helps to sort of store all your contracts, and then it has a way of finding out all the important obligations within those contracts. And you can also see the corresponding dates on which those obligations have to be met. And this all can be put in systems which can remind people about those obligations. The innovation that Riverdas has brought in this whole space is that if you have a contract, then it can read and understand the content of the contract, and it can highlight things that you will have to do as an obligation, or payments that you have to make. So pretty much like what you would have done, let's say if you had a relatively junior lawyer in your office who was sort of flagging up this kind of things, and then perhaps making an Excel sheet to remind everyone on a particular date a particular action has to be taken. This whole process has been put on autopilot, especially powered by the fact that we have a software which can read the inside of a contract. So it's very, very helpful in situations where you have contracts and you have to remember the dates on which you have to, let's say, renew those contracts, or you have to make multiple payments under those contracts, or you have to deliver certain documents, or you have to receive certain things from the other side. It's very, very helpful to remind you of those kind of obligations and their respective dates.
So just to summarize, thank you, Dipankar. Just to summarize, Dipankar, Surya, what we have done is that we have taught the software how to read contracts and to mimic human qualities of reading the contract. So basically, if you parse a contract through the Riverdas systems, in under a minute, there are identified business intelligence which the software can pick out and throw in a business intelligence understandable form. So basically, understanding the contract, where you are a very busy startup founder and you don't have the time to really look into a 60-page contract or a 30-page contract. You run it through the Riverdas systems and you get a summary, which with the collaboration with the platform with Flywork is often overseen by a human pair of eyes of the important provisions. What is the business which is or what is the business intelligence which is hidden within the contracts, that it does on managing executed contracts, on the pre-execution or before you sign the contracts. We have we have templates. For example, if like Dipankar and Roopa were saying, that if there are contracts which you're using repetitively, what you can do is you can generate those templates and keep them for an easy turnaround whenever required. We also have a section where you can do policy review. For example, like we were discussing that there are certain positions which are important for you. You can run a contract through the Riverdas system and do a review, and flags will go up where there is a displacement or where there is a change in the policy positions which you had set for yourselves. So you can basically draft, review, and store contracts intelligently through the Riverdas systems. Thank you for the question, Surya. I hope I've been able to answer you.
Yes, this is a wonderful technology as well. It's really taken the legal field to the future. So thank you.
Thank you. Roopa, would you like to close our session today?
Sure. Thank you very much, everybody, for listening in. So basically, we learned about, we saw how important contracts are to the startups, whatever size they may be, at whatever stage they may be. We saw why we do contracts. We saw the importance of different parts of contracting. We saw the human element involved. We saw the technology aspect involved. We introduced how important mediation is in resolving disputes. And then we finally spoke about the Riverdas Flywork partnership and how we are able to provide a cost-efficient and highly advanced way of reviewing and contracting, being part of the contracting process, which is a fantastic solution for startups. That's about it. And if anybody has any questions, please feel free to reach out to us. Obviously, we look forward to continuing to be part, both of CAMP and of TiE Bangalore. This is home, especially for me. Looks like I'm involved in all the organizations here, so which is great. Look forward to continuing to having this discussion. And we have ended up right on time, Shreya. So.
Thank you once again. And on behalf of the entire team, I would like to thank TiE for providing this platform, and especially to CAMP, which holds a very special position in my heart, for giving us this opportunity to come and speak to startups on contracting and contract management. Thank you.
Thank you so much for extending your wealth of knowledge to us as well. It's been really great. Thank you.
Thank you. Bye-bye.
Thank you so much, Juieen. Thank you, Roopa and Dipankar. Thank you so much. It was a wonderful session, and I'm sure founders have gone back with a lot of takeaways. And this video, for those who have missed a part of it, is going to be uploaded on YouTube. So do catch up over the weekend. I'm sure you'll find it interesting. Thank you so much. And thank you, Surya and the entire CAMP team.
Thank you, Surya. Thank you, CAMP team. Thank you, TiE.
Bye.